Good evening, ladies and gentlemen, and welcome to yet another of our webinars, Mercantile Barristers webinars to the construction industry professionals. And I thank you for coming. By way of housekeeping, our methodology usually is for me to spend the first half of the webinar addressing you, making my presentation to you. And hopefully when we get to the end of that the floor is open for Q&A, and then you can put questions that you may have depending on the matters that I have presented to you. Just another note to observe that we obviously had this webinar scheduled earlier on, and unfortunately coincided with the date that Her Majesty passed, and as such, the webinar was rescheduled to today. So if you signed up for the first webinar and even went as far as entering the waiting room, thank you for returning, and apologies that we couldn't continue on the day in view, of course, of the news that came out on that day. So thank you very much. Our subject matter this evening is final accounting, how to avoid common mistakes and contract disputes. Now, by way of introduction, my name is Samuel Okoronkwo. In case you have not been to any of our webinars, I started my professional life with a bachelor's degree in quantity surveying, which I practiced for about a decade and a half before taking a master's in project management and property development, and then became involved on a substantial amount of complex property projects, and then left it all, as it were, to go to law school, came out, went to bar school, and qualified as a barrister. So presently, what I do as a barrister is that I assist my clients in drafting contracts that achieve their objectives. I advise them from time to time on how to manage out disputes in construction contracts. I assist with resolving construction disputes that may well be by way of adjudication or arbitration. And when, of course, alternative dispute resolution is not working, I litigate construction disputes in the courts. And that is by way of introduction. Now, in this webinar, we will be looking at gaining a proper understanding of the final account and what it entails. We will look also at the mechanism for final accounting and the production of the final certificate, particularly with specific reference to standard form contracts. We'll look at the legal effect of the final account and the final certificate, and then we'll touch upon the common mistakes that are made in the course of concluding final account and try to look at how those may be avoided. I will refer to some case examples, and of course, I mentioned that we undertake a review service at Mercantile Barristers for clients that have a need for that service. Okay, so kicking off, what is final accounting? Now, one needs a definition for final accounting to grasp the whole effect of it. Now, I tend to describe final accounting as the consolidated financial summary, which is usually presented by the contractor to the employer after the completion of the works. It demonstrates the total sum the contractor considers that is due to it for the works that he has actually carried out, as distinct from the work that was set out in the original contract. So, of course, you start the contract with a contract sum, i.e. your tender value, and then you conclude it with a contract sum. Now, a final account is distinct from the interim payments that are made during the course of the contract, because those are, to all intents and purposes, payments on account. Now, the contractor will include in his final account all his valid contractual claims for additional payment. Under some forms of contract, the contractor's obligation is actually just limited to providing the necessary information only for the employer and the employer's team to calculate the final account. Now, the final account is also intended to wrap up all that has gone on throughout the project life cycle in respect of payments to the contractor. And while it may be possible to agree much of what has happened during the project life cycle, the process of trying to reach the final figure, the final account, the final agreement can often become complicated. It is time consuming, as most quantity surveyors will tell you, and the process very easily becomes very adversarial, and it can lead to disputes. So what does final account entail? What it entails in your final account, it depends on the form of contract as to what it entails, what is included in it. However, generally, it will include the variations, any loss and expense due to delay and or disruption of the works. So things like increased preliminaries, overheads, wasted management time, loss of profit, loss of productivity or uneconomic working, increased costs resulting from inflation, which is very topical presently, interest for non-payment of money is due, any finance charges. Now, it would also include an allowance for liquidated and ascertained damages, assuming those were applicable. You will have your provisional sums, which will have to be adjusted, the release of retentions, the adjustment of prime cost sums, and any payments relating to the opening up and testing of the works that may have already been covered up. And it will also cover fluctuations and any contra charges that will be applicable during the course of the contract. So what mechanism is usually adopted for calculating the final account? Now, the mechanism for final accounting, the precise mechanism for final accounting always depend on the wording of the contract. It differs across the various standard forms of contract. The wording of the relevant clause will determine what the contractor has to show in order to establish its right to any additional payment that it may be asking for, and how it will be calculated. Now, it may also impose conditions precedent on the contractor prior to the recovery of certain sums. So let's take them bit by bit then. The JCT contracts have some predefined mechanism for arriving at the final account. So the JCT standard building contract, I've taken the width quantities edition 2011 and 2016. So JCT 2011 and 2016. The final account provisions, I can summarize them as follows. The starting point is clause 4.3 in both contracts. Now, it lists the only situation in which the contract sum may be adjusted. Now, these will include the grounds for any entitlement to loss and expense. So in JCT 2011, this is split into 3 categories. They cover those items where adjustments are to be made, where deductions are to be made, and then where additions are to be made. So it's either adjusted, deducted, or added. Now, in the 2016 contract, is a simple single list. It's not broken down into whether it's an adjustment, a deduction, or an addition. So if you look at clause 4.5.1 in the 2011 contract and clause 4.25.1 in the 2016 contract, it states that not later than 6 months after the issue of the practical completion certificate, the contractor must provide a relevant person. Now, the relevant person in this case is often the contract administrator or the architect, or indeed the quantity surveyor. The contractor within 6 months must provide the relevant person with all of the documents necessary for what will be the final adjustment of a contract sum. So the obligation of the contractor here is to give the information. Now, in clause 4.25.3 of the 2016 contract, it expressly provides that if the contractor fails to supply this information, then the architect, the contract administrator, or the QS may, after having given 1 month's notice, complete any ascertainment of loss and expense and statements of adjustments on the basis of the information that is in its possession. That is to say, the contractor, you have an obligation to provide this information, but if the contractor is not meeting the deadline, then the contract administrator is obliged to serve a notice, in other words, to make time of the essence. That notice period is 1 month, and if that information is not provided, the contract administrator may then proceed with the information that it has to hand. In clause 4.5.2 of the 2011 contract and 4.25.2 of the 2016 contract, the relevant person, i.e. the contract administrator, must, within 3 months of receiving the information that I've just described, ascertain the loss and expense due under clause 4.23 of the 2011 contract or 4.21 and 5.3.3 of the 2016 contract. I'm afraid I have to litter this with these relevant clauses because they're actually very, very important when you come to practice. So in addition, the QS must also prepare a statement of all adjustments to be made under clause 4.3. The architect or the contract administrator then will send a copy of this information to the contractor within that 3 months period. Now, in clause 4.15.1 of the 2011 contract and 4.26.1 of the 2016 contract, the final certificate must then be issued by the architect or the contract administrator not later than 2 months after whichever of the following 3 events occurs last. So the first is the end of the rectification period. The second is the date of the certificate of making good under clause 2.39, and the date on which the architect, contractor, or the contract administrator sends the information to the contractor. That is the statement and specifying the ascertainment prepared under clauses 4.5.2, the 2011, or under clause 4.25.2 or 4.25.3 of the 2016 contract. So under clause 4.15.2 of the 2011 contract and 4.26.2 of the 2016 contract, the final certificate confirms the difference between the contract sum as adjusted in accordance with clause 4.3 and the total of all the sums due in previous interim certificates. The difference between these 2 sets of figure, the difference set out in the final certificate is the balancing amount that is due to be paid by the relevant party. It's very important, the relevant party. So the presumption always is that the payment flows to the contractor. However, in circumstances where all the items that I've previously listed have been taken into account and it leads to debt, it results in a deficit, it presupposes therefore that the payment flows from the contractor to the employer. So it's important to be mindful that the payments can go either way. Now, what about the NEC engineering and construction contracts as distinct from the JCT contract? Now, the NEC, in essence, is broken into the NEC3 and the NEC4. Now, under the NEC3, there are no final account mechanism provided. So the parties in there tend to provide theirs by introducing some bespoke clauses, which is usually classed as the Z clauses. Under NEC4, the final account process is less detailed than it is in the JCT contract. Under clause 53.1, the project manager in that case carries out an assessment of the final amount due and certifies the final payment, provides the contractor with details of how the amount has been assessed, but he must do so no later than 4 weeks after the defects certificate or 13 weeks after a termination certificate. The final payment is therefore made within 3 weeks of the assessment, unless, of course, a different period has been set out in the contract data. Under clause 53.2, if the PM for any reason fails to carry out the assessment within the required timescale, the contractor may simply just issue its own assessment for payment within 2 weeks, unless, of course, a different time period has been set out in the contract data. Under clause 50.9, for cost-based contracts, the main options see to the finalization of the defined costs is usually the contractor's actual costs minus any disallowed costs. So what is the legal effect of the final certificate? Because of course it's all right, the first thing is to get the final account done, agree it, and then the final certificate is issued. But what is the legal effect of the final account or the final certificate? Now, the final certificate could amount to, in law, it could amount to conclusive evidence as to the matters that it covers, subject only to it being formally challenged within a prescribed time period. Now, in such a case, if it is not formally challenged, the parties will be unable to have it reopened or reconsidered. Now, depending on the wording of your particular contract, it could be conclusive as to the payment that is due, as to whether or not it's been made and the amount, the quality of the work executed, matters relating to latent and patent defects, or a mixture of all of the above. It depends on what the wording of the contract provides. Now, how do these contracts look at it? JCT contracts, again, giving it the legal effect. So, under the JCT contracts, clause 1.9 of the 2011 and 2016 contracts, with certain exceptions, the final certificate shall, it states this, that the final certificate shall have effect as being conclusive evidence that, insofar as the contract requires the quality of materials and goods, or the standard of workmanship to be delivered is to be subject to the architect's or contract administrator's approval, such quality or standard was to its reasonable satisfaction. So if the certificate is being issued, the standard that were set out as being to the architect's satisfaction is deemed to have been to his reasonable satisfaction. Okay, provides the opportunity for the employer to bring claims for defective materials or goods or workmanship at a later date will therefore depend on how the contractor's obligations have been couched in the contract. In other words, was it subject to architect's approval, or is there a defined specification which the contractor was required to meet? Of course, as stated in my previous comment, if it was to the architect's satisfaction, then it is deemed by the virtue of the issue of the certificate that it has actually attained that level that was specified in it. That the necessary adjustment to the contract sum have been made, except in respect of any obvious computation errors. It also is conclusive that extensions of time under clause 2.28 have been given. Excuse me, provides that reimbursement of any direct loss and or expense agreed, ascertained or valued under the contract. In the JCT 2011, this is expressly referred to reimbursement pursuant to clause 4.23 is in full and final settlement of all the contractor's obligation arising out of all the relevant events. Okay, so what that is in essence saying that any loss and expense that is supposed to have been reimbursed by virtue of that of the final certificate being issued, that it has in fact been issued. Okay, so clause 1.9.2 of the 2016 contract, that if adjudication, arbitration, or other dispute resolution proceedings are brought within 28 days after the issue of the final certificate, the binding effect of the final certificate in those circumstances is suspended. So if you're contemplating bringing proceedings and you are in receipt of your final certificate, now you should be mindful that 28 days is a critical time within which you must start. Otherwise, you may well lose the benefit of the binding effect of the final certificate. Now, suspension of the binding effect of the certificate ends when those proceedings are concluded. The final certificate then becomes subject of any judgment or settlement that is reached in those proceedings. Now, the same position is also repeated where court or arbitration proceedings follow an adjudicator's decision concerning their final certificate brought within 28 days. So by way of illustration, imagine that the final certificate has been issued. You have commenced adjudication proceedings, and of course, that suspends the, if you like, the finality of it. The adjudication then ends. At that time, the final effect of it is supposed to kick in, but imagine that the adjudicator's decision is then challenged within 28 days, then the binding effect is still not biting until those subsequent proceedings conclude, provided, of course, that they are commenced within the 28-day window, which is important. So if we look at clause 1.9.3 of the 2016 JCT 2016 contract, proceedings are deemed to have concluded where neither party takes a step in proceedings for a period of 12 months. So there are circumstances where proceedings begin, and for some reason or another, the party having carriage of it, i.e. the claimant in the circumstances, fails to take adequate steps, and the defendant just sits back. If a period of 12 months passes without the parties taking any step in the matter, then those proceedings are deemed to have been concluded for the purposes of the JCT contract. Clause 1.9.2 to 1.9.4, the 2011 contract, addresses the same situation slightly differently. The final account is conclusive if proceedings are not brought within 28 days period. Now, the courts are, of course, willing to enforce such conclusive evidence clauses, but as you will see in case law, they often are sympathetic to parties who are, of course, subject to such tight deadlines and have not been able quite, for cogent reasons, to meet it. Now, under the NEC contracts, the NEC4, remember that NEC3 has no such provisions. The NEC4, the final assessment, which is the final account equivalent, there is conclusive evidence of the final amount due under or in connection with that contract, unless, of course, it's referred to dispute resolution within a stated timescale. The assessment of the final amount is changed if the parties agree. An adjudication decision as to the final amount is not referred to court or arbitration proceedings within 4 weeks, or a recommendation of a dispute avoidance board as exists under the NEC as to the final amount is not referred to court or arbitration within 4 weeks. Now, under clause 53.4, the revised assessment becomes conclusive evidence of the final amount due. The legal implications under the NEC. So what are the common mistakes and how should practitioners go about avoiding them? So I summarize them like this. The critical common mistake that is made more often than not is leaving the final account to the end of the contract. Now, to my mind, final accounts should start at the commencement of the works. It should remain ongoing throughout the process of the work, and it should then culminate on completion. So if your final account ought to be a living, dynamic document that actually starts life at the beginning with the contract sum and remains active until the end. Now, contract sum regularly must be adjusted to take account to include all contractually allowable changes to the price payable to the contractor. So as soon as you become aware of it, it should be factored into your final account, and it should be disseminated. It should be shared freely between the contractor and the employer. Now, contractors often save up on their claims presented to the employer for resolution after completion. Now, to my mind, this is always ill-advised. So if you hit people with a claim at the end of the contract, you wouldn't be surprised if all you receive is resistance, because of course, if all this was happening throughout the project life cycle, it would of course naturally be incumbent upon you to disclose it and to share it. So the final account will give rise to a balancing payment to the contractor or to the employer, vice versa, because of course, when you're articulating a claim, there may well be a counterclaim. So under the standard form contracts, the final account includes the issue of the final certificate or the final statement formally recording the amount due to or from the contractor. It can flow either way. It may also be conclusive of the matters that I've just mentioned in the contract, with all sums due to the contractor taken into account. I'll touch upon the possibility of the employer and the contractor doing a deal to settle, and I'll look at some payment and payless provisions of the HGCRA, which is the Housing Grants, Construction and Regeneration Act. In essence, the statute that establishes adjudication. Now, of course, there are issues, of course, that we touch upon regarding consciously not investigating how much a contractor is paid, then with a view to seeking to recover it after all. So let me give you some case examples that illustrate some of the things that I've been talking about. The first case that I tend to pick upon is the University of Brighton versus Dove House Interiors in 2014. The parties in this case were unable to reach an agreement over the value of the final account and therefore the final certificate. The contract administrator issued the final certificate, started the 28-day time clock for dispute resolution proceedings to begin. The parties then reached an agreement between themselves to increase the 28-day period to 66 days in order to allow them more time to negotiate. Very reasonable, you will say. But then came day 65, the contractor served a notice of adjudication. In other words, firing the gun, the first step in the adjudication process. But the contractor named the wrong nominating body, the wrong adjudication nominating body. So the notice had to be corrected and reissued in order for the adjudication to be valid in accordance with the contract. And of course, one party contended that the matter can no longer be adjudicated because of the loss of it being out of time. The court held in that situation that the adjudication had properly been commenced for the purposes of the conclusive effect of the conclusive evidence clause in the contract. It kept alive the contractor's right to challenge the final certificate because, of course, if his right to adjudicate had been extinguished, therefore he couldn't challenge the validity of the final account in that case. That's the significance of the time and how the court accommodates you there. Now, in the Scottish case of McLaughlin versus East Ayrshire in 2021, the Court of Sessions agreeing that Mark Gibbard agreed with Mark Gibbard 2009 Settlement Trust versus early developments was applicable to the final certificate provisions in the JCT 2011 for use in Scotland. The court in that case held that the parties were not entitled to rely upon the conclusivity of a final certificate to obtain interim payment whilst proceedings to challenge the final certificate itself were already underway. Now, if court action is raised to challenge the sum due under the final certificate within the relevant time period, the party cannot therefore obtain payment of the disputed sum by commencing separate proceedings after the relevant time period and relying upon the conclusive effect of the final certificate in those proceedings to obtain payment pending the outcome of the original action. Now, nothing in the contract indicated that the conclusivity provisions were intended to work in this way, which is obviously consistent with the obiter dicta in the Mark Gibbard case. So this decision indicates that the approach of the Scottish courts to the effect of the final account will largely align with the English authorities. So it doesn't really matter where they're doing it in the country. Another case that I tend to touch upon is the YJL London versus Roswin Estates. It illustrates the importance of ensuring that a settlement agreement is clearly drafted. So this is a warning for DIY drafting. Now, the negotiation of the final account had proven to be protracted in this case, but the parties eventually reached a compromise and signed a formal full and final settlement agreement. However, the employer then sought to change his mind. He sought to argue that the contractor was nevertheless still obliged to comply with the relevant clauses in the contract, which required the contractor to submit a final account document, and that its failure to do so meant that the client the employer in this case did not find himself bound to pay the sum agreed in the settlement agreement. So he reached an agreement, sought to change his mind. The contractor has not complied with the contract in submitting the document and not paying. So unsurprisingly, the court rejected this argument and held that the parties had intended the settlement agreement to displace the provision in the contract for the contractor to submit the information. The court, it did recognize that in the absence of any express reference to them, it was more difficult to say whether the settlement agreement covered claims for latent defects. To avoid subsequent uncertainty and possible challenge, parties are always advised to ensure that any settlement agreement is clear and unambiguous and that it covers all the issues that it is intended to cover. So this is a warning, of course, if you're drafting such an agreement, you can do worse than get professional advice and have it properly done, just in case things were to go wrong down the line, as they often do. So under the Housing Grants Construction and Regeneration Act of 1996, the payments under construction contracts, I think there's the next thing that I'll touch upon. Now, the provisions there in essence says that where the employer fails to give a payment or pay less notice under the construction contract, it is required to pay the amount stated in the contractor's payment notice. It may simply be a form of application for payment. So you receive a payment application from the contractor and pay it, or otherwise serve an appropriate notice saying that you're going to pay less. If you fail to do that, then you will find yourself bound to pay that application, whether or not you agree with it, because time has passed. Now, for some time, there appeared to be a distinction between interim payments and final payments in respect of the ability of the employer in such circumstances to refer the dispute to adjudication as to the true value of the works done. So such cases as Kelka Projects Limited in 2016 and Harding Trading in 2015 held that the employer was able to do so in respect of final payment, while other cases such as ISG Construction held that it was unable to do so in respect of an interim payment. However, in Grove Developments in 2018, it was actually upheld an appeal. It was held that there is no such distinction. The employer can adjudicate the true value of the works in respect of either the interim payment or final payment, notwithstanding its failure to give the requisite notices, but only once he has paid the sum in question. So in the subsequent case of M. Davenport Builders Limited, it was confirmed that the requirement for the employer to first pay the notified sum before commencing an adjudication as to the true value of the work applies in the context of a final account. So in Broadsley London Limited, this is a Prime Asset Management in 2020, the court held that an employer was not entitled to commence an adjudication to determine the final account in circumstances where it had not paid the amount stated in the contractor's interim payment application as required by an earlier adjudication decision. So the adjudicator had in the first instance said that this is the amount you pay, that's the amount that is in the certificate, and the employer wanted to go and adjudicate that without having paid that adjudication decision. So I mentioned the conscious decision not to investigate. Now, in this case, parties should be mindful of the Court of Appeals rulings in Leslie versus Farah in 2016. This case concerned a scenario in which there was no agreed final account mechanism or certificate at all. The parties entered into an oral agreement to say, okay, we agree that this will be our final account. As is often the case, the employer then sought to recover overpayments that he had made to the contractor during the progress of the works, relying on the grounds of mutual mistake. The court held in that case that recovery was not possible as the employer, on the facts, had taken a conscious decision to pay the sums requested by the contractor without investigating how valid or otherwise that those figures are. So you can't, in the first instance, not bother to look, and you pay the money, and then you subsequently turn around after the event and tell the court, oh, I've overpaid them. As they say, you can't try to shut the gates after the horses have bolted. So in essence, that's the, if you like, the primary content of the webinar that I'm giving to you. The only other point to mention is that because we are frequently requested to do so, we do a review service for clients who are in the course of contracts that are likely to become contentious, in which case they want their numbers and the documentation reviewed so that they can get advice as to whether they're heading in the right direction or not. Or in some cases, they're already thick in the dispute, and one can look at it retrospectively with a view to how we can assist. So in essence, that is the end of my webinar presentation to you. And the floor is open for questions and answers. So that's the end of my presentation. So any questions will be welcome at this stage. And I thank you, of course, very much for attending and listening.
It's all right.
Sorry?
Samuel, can I ask a question?
Yeah, sure, go ahead.
So if there's delays on a project or mainly from variations, so a variation changes a program of works, then when you get to, and you've kind of hinted at this, but I wanted to kind of draw you on it. You get to the final accounting stage, and whether it's a legitimate query or a not legitimate query, shall we say, people decide, or the employer decides that actually that program, that variation shouldn't have had a material change on the program, and starts to invoke penalty clauses. Have you ever seen something like that? Is it just a cash grab, or is that a legitimate way to do things?
It depends on whether or not the final account has been reached and the final certificate has been issued. Now, prior to the issue of the final certificate, all of the interim payments made are subject to adjustment because they are all payments on account. However, if the final certificate has been issued, then it's conclusive that the amount paid was the amount that the parties agreed that was sufficient. Now, whether or not you're entitled to open it to contest is whether you bring your challenge to it within the 28-day period. And as we saw in the case of conscious, if you like, attempt not to investigate, if you've paid the money without taking reasonable steps in the process, then of course you may have lost that right. But then in any event, you have 28-day period within which to raise that challenge. If you don't raise that challenge within 28 days, you may well find that the opportunity is lost.
Thank you.
Okay.
Samuel, can I ask a question?
Yeah, sure. Who's asking?
That's Paul.
Hi, Paul.
Hi, Samuel. I'm working on a contract where the contract terms are so vague that all that really applies to the scheme for construction contracts.
Oh, okay.
When assessing contractors' applications, occasionally we've issued a payment notice.
Pay less notice, you mean?
Well, a payment notice,
Okay,
which is less than the application. And the contractor said, well, you haven't issued a payless notice. But my understanding is that if you've issued a payment notice, that may be for less, and therefore a pay less notice would seem to be not required because you've stated you're going to pay less with a payment notice. I don't know if that's the case.
Yeah, belt and braces. I would, if I were you, if this is being challenged retrospectively, slightly different. If I were you, I'll pay less notice. Although it's called a payment notice, I specifically advise that you stick the word pay less notice so that it is clear that you're actually going to pay less than the contractor is asking.
Yeah.
But I don't suppose in your case, you're a PQS, I take it.
I'm an architect.
You're an architect, okay. So I take it that the contractor has not been brave enough to take that to adjudication, has it?
Not yet. It's something that's come up a few months during this contract, where there's been a discussion about the valuation and an agreement's eventually been reached, but the job is approaching the culmination. And I imagine perhaps the review process you offer may be something I'd suggest to the client to try and tidy things up.
Oh, that may be wise. Okay, I can see it. Did you say it's reaching termination or is reaching
culmination? In that the job is almost finished.
Okay.
You know, but it was a 11-month contract that's 12 months late. You know, so there's it's a great mess. I came in very late in the day to help the client tidy up the mess that they got themselves into. With
any application by the contractor for an extension of time?
Practically none. No, there's been nothing in writing.
Wow. Okay, that's interesting. What's the value of the contract?
1.5 million.
Interesting. Okay. No, I think that would be worthy of attention. Well, it depends. Has the client actually, has the employer paid the contract sum?
It's approaching the contract sum now, but I think there'll be, you know, the employer, I think, would be sensible to take legal advice on whether they want to be claiming some sort of loss and expense because of the substantial overrun. Yeah. But equally, the contractor may feel that they've got grounds for prolongation costs.
Correct. That's often the case. Well, I didn't ask you because, of course, you didn't start the contract, but was there any notices issued to the contractor to proceed duly and diligently with the works?
No, there was a set of drawings issued by the employer. The contractor said, "I'll do it for this much in this much time," and they got building.
Oh, okay, classic. Yeah, I can imagine. Okay, no, hopefully, yeah, if we can assist you, if I assist the client, that would be, I'm sure.
Okay, I'll email you tomorrow, maybe.
Okay, that'd be fantastic.
Thank you, Samuel.
Thank you, Paul.
So you've got time for another question, please?
Oh, we have time for questions. Yeah, go.
It's Tobias here. I'm also an architect and contract administrator for a project that has gone significantly past the contract end date, and the employers have been nervous about terminating the contract because they think that gives an excuse for the contractor simply to walk away. But the contractor really isn't proceeding diligently with the works, and so I have at least persuaded him to issue a default notice to the contractors, at least a marker in the sand that he's not proceeding. And what I wanted to understand, it's not strictly a final account, but if the employer was to ask me to terminate the contract, and of course at that point he then finishes the work with other tradesmen, we have a record of what he's had to pay them, then I understand, we're working with the minor works contract here, which is not quite so specific, but it's a good basis. My understanding is then within 3 months of the actual scope of the project being complete, I can then put together all the list of things that you've described, loss and expense, adjustments to the contract, and so on and so forth. And then I issue a proposal for a final payment. Now, and then I think, normally speaking, I'd hope that all the things in terms of the steps, adjudication, arbitration, and so on would follow. But my question to you is, if one's actually terminated a contract, does that effectively make all the previous contractual obligations null and void? So is the contractor, for example, no longer liable to make good defects? Is the contractor no longer liable to follow the employer's requests in terms of adjudication and so on and so forth? What does the process of terminating do to those various contractual obligations.
Okay, very interesting point. Now, for you as an architect, it's imperative that you ensure that appropriate steps to termination are taken.
Yeah.
Because if there are defective steps taken in determining the contract, the determination becomes a repudiatory breach on the employer's part.
Absolutely.
That's a very important point for you. And the second point is that when you bring that contract to an end by way of termination, all of the duties and obligations ceases at that point, because recall that what you're going to do is bring third parties to try and complete the work that he has begun.
Yeah.
So at the outset, any contractor that you bring to complete the works begun by another will condemn everything, will accept liability for nothing that has been done before their time. By the same token, the contractor that you've just ejected from the project will deny liability for anything that is alleged to have gone wrong because it was done by the subsequent contractor. So you potentially are going to be in a difficulty as to where you are going to require the contractor that you've ejected from the project to return to comply with obligation from which you released it. So
My assumption has been that we won't be able to get him to come back, but we nonetheless will be able to value the additional works that have had to be done to complete the project, and that as long as there's a reasonable documentation of the status of the work with photographs, together with a brief written schedule of what the new tradesman thinks he needs to do to complete the works as set out in the contract documents, then we at least have documentary basis for issuing this final payment, saying, right, now this is what the contractor owes the employer based on all those things. Now, of course, we're concerned that the chap's company may fold, he may have liquidity issues. So my employer's never going to get the money back, but that's a separate issue. Debt recovery is a separate issue. Contractually speaking, am I right in saying that, as you say, as long as the termination has been generated contractually, and that we have a good documentary evidence of what work was required to complete the work set out in the contract, that is a sound legal basis for then recovering the outstanding costs of the employer by dint of termination of the contract?
I think it is appropriate for me to tell you, but I get the picture that you're painting, but one requires to ask you a few more questions, which perhaps is not appropriate in the wider forum that we're in.
Sure.
So this perhaps warrants a discussion outside of the forum, because in order to legally found a determination, there has to be culpability on the part of a contractor. The fact that the work has overrun is not necessarily the contractor's responsibility, because that contractor is entitled under the provision of the contract, even minor, as to the relevant events that may have caused him not to be able to proceed duly and diligently. So there are key critical steps that you have to take, which I say, as I'm saying, warrants discussion outside of this forum. So before you even contemplate terminating, you're going to put key pieces of correspondence, raising queries with the contractor, and his answers to those would then enable you to fix your determination so that it is solid. Because there are two key things that are, if you like, the main post-termination. One is safety and quality of the works that's being left. Consider being inherited as it is by the employer with certain responsibilities to the contractor, and second, ability to recover from or be liable to the contractor. I did a case in which a project contract administrator proceeded and terminated the contract because of overrun and not resourcing the project in order to keep up with the construction program.
Yeah.
Post termination, In fact, 7 days after termination, the contractor, a major contractor, issued an adjudication notice on the employer alleging repudiatory breach. The employer then took the letter to their solicitors, and the solicitors said, your contract administrator did indeed determine wrongfully. So the contract administrator had a notice served on him of professional negligence claim that the employer will seek to recover from him however much they pay the contractor. And of course, I was brought in by the contract administrator who said, oops, I have this challenge. Having looked at the matter, what I suggested in that case was, why don't you go to your employer to retain me to fight the adjudication? Because if it is successful, you're off the hook. But if it is unsuccessful, of course, then there is the difficulty between you. So hold hostilities in the camp. As it turned out in that case, we succeeded in defeating the contractor, not because the determination was properly done, but because we were able to, as it were, legally shift the goalposts onto grounds upon which we could have succeeded. And we did succeed. So there are specifics to go through. To go through with you, just to ensure that you're on the right track, and then the employer will then be, if you like, better informed on the consequences of determination for himself. So you want to take your employer with you.
Sure. So should I'll background at this point and leave questions to others.
If you drop me a line outside of the phone, one of my clerks will set up something, and we can look at that in greater detail.
Okay. Thanks very much.
Good.
Hi, Samuel. My name is John. I got a question, 2 questions. It is from the previous speakers.
Okay.
One is about the applications from the contractor. So I got a job I'm working on is a design and build, JCT design and build project.
Okay.
So the applications coming from the contractor say they're about 223K per month, but I do my assessment, we come to about 80K as for the payment notice advising the client. And within that, I find lots of front loading from the contractor. So one of the previous speakers talked about issuing a payless notice in that case. Can you really issue a payless notice when you're just making your assessment, or when I've done my evaluation, my assessment for the advising the client that this is the amount that we think that the contractor should be paid for?
Okay, well, you're an architect, correct?
No, I am a PQS.
You're a PQS.
Acting as an EA on this job.
Okay, this is the JCT with contractors design.
Yes, that's right.
Now, the obligation to issue a payless notice is the employer's.
Okay.
And if you are the employer's contract administrator, you assume that role for the employer.
I am the EA.
Okay, you're the employer's agent on that job. And I would, for your purposes, recommend that when you do your assessment, it has to include a payless notice.
Okay.
Okay, that's the straight answer to your question, because if the contractor is claiming 200,000 and you're only assessing it at 80,000, there is a substantial gulf between both of you. Now,
exactly.
You mentioned a very familiar wording of front loading. You identify the front loading, and then now you obviously have a construction program.
Yes, we do have a construction program, but the project is well overrun. We should have finished by January this year, and we're nowhere near finished.
Ouch. Okay, so the construction program is out of the window as we speak.
Correct.
Is there been an updated program issued?
Yes, there was one which has been issued, and
It's a completion program.
No, it's just being revised. We kind of ended up having like kind of a program review, cash flow meetings with the contractors and the clients, just to help the contractors come on to see how they're progressing with work. But they are struggling financially. They don't want to admit it, but I did highlight it to my clients, saying they have cash flow issues because you see less tenants on site from other subcontractors.
Yes.
And we're seeing high staff turnover from the company.
Now, is this management staff or operatives?
From the main contractor, operatives.
Operatives, okay, but you're still maintaining the management staff.
Would you say management in terms of
the site manager is still there, the contract manager is still there?
They are there, but they keep changing from time to time. In a month, the main contractor has lost, he has changed site managers, four or three of them in a month.
Not good.
Not good, exactly.
Yeah, not good. Anyway, your specific, this is a critical time. What percentage of the job would you say has been done?
So we're about 81% on the job being done.
Okay. Will you have paid 81% of the contract sum yet?
Technically, yes.
Okay. All right. So, and you have no issues with potential defects?
Well, the quality of the work is bad at some point, but we do have a clerk of works on board highlighting all these issues. And just in summary, within her trackers, we got over 200 items that are not matching the quality for the work. That's how bad the project is.
Okay, well, I think both yourself and your employer should be preparing for what is obviously going to be an acrimonious termination of a contract.
Okay.
Yeah, because there is a substantial difference between what the contractor is asking and what you're paying, and that is also not being borne out on site. I think your employer is entitled to insist that there be a proper, clear program that is produced for completion, and you want to see that program resourced. So I don't know, what sort of project is this, residential or commercial?
It's residential. Residential.
It's residential. And
yeah.
Am I right in saying that it's all waterproof?
It's actually the two projects, but running the same contractor. One project is fully waterproof, and the other one is not waterproof at all. It's a lot of frustration in the project whereby that it's not waterproof since last year, and up to now, they just keep crossing their fingers, hoping the weather is going to be good. They're doing the internal plasterboards, and they've removed that 3-4 times under the instruction of the clerk of works, and it's just going on and on and on and on again.
Because they are being defectively fixed.
Yes.
Well, now that is a problem, because whenever a contractor puts up work and takes it down, they will seek to charge you for it. And if it's gone up and down 3 times, that is triple waste. I think your employer and yourself, of course, require proper preparation, because you should have a completion program that is resourced. And when it is resourced, you really are going to be looking for the number of operatives, the man hours that's been allocated, and you want to check. Are you including materials on site in your valuations? We do including materials on site, and from my assessment, I say the contractor is just milking the project, whereby he's flooding the project with materials on site, less progress on site, but lots of materials on site where he can claim money's out. So. Okay, now the materials on site, have you taken appropriate steps to ensure that the title in them is retained by your employer? I have taken appropriate steps, and I have asked for them for delivery notices and invoices, which they're pretty adamant to provide to me. But I say, I stick to this and I need this to be provided, but they don't want to give it. So it's kind of, a whole lot of frustration there. Okay, well, again, that's another matter that we can talk about outside of the general session. Okay. I can see where you're heading. There are some sort of banging your head against the but there are 1 or 2 steps you can take quite literally to put a rocket up them and then, get them moving. Otherwise, then you're setting a clear landing point for your employer. Okay.
Okay. My second question.
Okay, that was your first. After that one, I think there's a person whose name is Waleed.
Waleed set his hand up for. I promised him he's next. So.
Okay, thank you. Okay, go for it, John.
So the second question is, so on the same project, so we are overrun with the program, but the client doesn't want to apply LEDs. I've advised the client to apply LEDs so that we can get some incentive from the contractor to progress on with the works. But the client is saying it's too risky at this point in time to apply LEDs. And from my calculations, we are almost about 200, almost £2 million of LEDs to be applied. Can this be brought in during the final account or not, if the client decided to?
Well, you will recall my presentation that the earliest possible notice is preferable, but your client is trying to, as it were, play a very difficult hand deftly by saying, I think if I give notice of liquidated and ascertained damages, the contractor will simply walk away and leave me with greater difficulty.
That's right.
Now,
yeah.
Have you been serving the relevant notices? Whether or not the LEDs are applied, are you serving relevant notices of non-completion or not proceeding duly and diligently with the works, or falling behind the contract program without taking appropriate steps to return the works to program?
I've been serving all those notices for non-completion, and I've been serving notices for about the quality of the works being done on the scheme. So what we call the NCRs as well. So all those are being served.
Okay, well, as I said, your employer is mindful that he's about potentially £2 million in liquidated and ascertained damages that he hasn't begun to claim.
Yeah.
Can the contractor stand such a claim?
No, actually, they will go bust. They will go bust.
Okay, so
that will wipe out the whole company.
Well, so at this point, I think that your employer is deliberately hand-holding them to completion.
Yeah.
Are these residential development for sale?
Yeah, part of them are for sale, others are just for social housing.
Social housing, okay.
Yeah.
Is your employer at risk of foreclosure by his lenders, considering what's happening to interest rates now?
It's not something I've discussed with the employer, but
not something that he may discuss willingly with you.
With me, but I'm not going to mention them, but it's a big housing association. And for me, it is more trying to get the employer say, look, if we apply LEDs now, we get the incentive, or terminate the contract on one of the projects, so we get somebody in, because the quality of the works is really poor, and whereby the works are being redone time and again and again and again. So it's just that sense of frustration, because the risk for them, they're saying that the contractor is going to walk away from site and say, yes, there's that potential of them walking away from site, because one of their group companies, they say they sold the shares to another company for £1. So there's already red flags there, and I've already told them, but it's just the client is not really taking on that.
Maybe your employer requires somebody else to put to them the greater risk that they are potentially exposing themselves by letting that continue.
Yeah.
Yes, because if your employer is a housing association.
Yes. Yeah.
Okay. Well, John, this is worthy of a separate discussion, because there may be. Now, John, what's your surname? You've got John Wang.
Iga. IGA.
Yeah. John, why don't you drop me a line after this, and then we probably take this one step further, okay?
Okay, cool. Thank you very much, Samuel.
Okay, it's a pleasure. Good.
Thank you.
Okay, now we have to let Waleed in.
Hi, Samuel. Thank you so much for your time.
Good evening to you, and apologies that your hand's been up for
No,
such a long
fine.
time.
It's not a problem at all. First of all, I did want to thank you for your presentation. It's very informative. And My question was regarding, so we've got essentially a contract, an EC4 option E, doing an ECI for design and build for the client. Obviously, you can tell that I'm from the main contractor, and we running a few issues, essentially mainly around budgeting. So the client essentially is struggling to secure further funding. And what's been happening over the last course of the year, I've taken this on halfway through, probably less than halfway through. I've just recently joined them. So what's been happening on a month-on-month basis is that we get paid on obviously the defined cost incurred. So we submit our applications on a monthly basis. The client has been agreeing them and paying us on account. But what they are doing is they are refusing to settle the quotations for the changes that we've incurred. So essentially, we have a lot of compensation events. Yep, exactly. And they agreed in principle the compensation events, but when it comes to the quotations, they've constantly been asking us to resubmit, because they simply disagree.
Well, sorry, disagreeing on what basis?
So essentially what's happened is because of the changes that are taking place, we've incurred additional resources to solve the design. We've illustrated that in our changes, and they still refusing them. So what they're doing is they're refusing our quotations based on that, and they are also refusing. So they accept the program. Obviously, we submit their program once every month again, and they accept it, but obviously make comments about that they don't accept the prolongation which is due on those changes also.
Is it that they are saying that they are not, that you're not using pro rata the rates at which you used at tender, or are they saying that the resources you're allocating to the changes are excessive, or they're just simply saying we are conveniently refusing?
Second point. So it's not the rates. Obviously, the rates are what they are, plus any adjusted rates for the inflation. It's the second point. So it's to do with the amount of essentially inefficiencies. And so my final account is due next month, and I can see what they're going to be doing is potentially just saying they're going to pay us all the contract sum plus any agreed compensation events and nothing more.
And they disagreed. They disagreed with what structure are you actually building?
So we do a lot of highway works for the clients.
So is this roads?
Surfacing.
Or is it bridges?
No, not bridges. So paving and surfacing.
Okay, paving and surfacing. Okay, all right. And now your final account is due in a month's time.
That's right.
Okay. Well, I think it's appropriate that you serve some notices and tell me when they are paying you, are they serving you with any notices that they're paying you less than you're asking?
So they are, but this is the other irony, and I thought it might relate to the last case you mentioned about Leslie and Farrar, which is essentially they're paying us. Let's say we've done the works for up to 95%. They're paying us like 91, and they and obviously the dispute. Sorry, not the dispute. The unagreed compensation events probably amount to about 30%.
Right.
So we're in a situation where we've got essentially the money, but the struggle here is to push them to obviously increase the purchase order and guarantee income. Yes,
to get your extras. Well, it seems to me that you need to it seems to me that you need to put some key pieces of correspondence on record.
Yep.
Because you may well what's the overall contract sum here?
It's coming up. I mean, this one is not much. It's about 400,000 for the EPI.
Yeah. Okay. It seems to me that you need to put some key pieces of correspondence on record, which would assist you greatly when it comes to resolving the final account stage. Again, it's something that, based on what you're saying, and probably I need to see one or two things more, could assist you with dictating something that you can put in writing and then give them, and that will lock in. Because you need to present your case in a particular way, because what they're doing is skillfully getting away with what they can pay you, but giving you appropriate notice of what they won't pay you. But then it doesn't mean that you're not entitled to it. It simply prevents you from, as it were, precipitating an adjudication now. But the final accounts will still have to be done. But you're thinking appropriately to set yourself up for final account resolution.
Yeah, I mean, I have been doing pretty much everything in my control to sort of make sure that we obviously issue them also budget updates or budget estimates to the completion of the work. So we send them those to include obviously the compensation events. We've issued out multiple early warnings along with the compensation events that have been, to be honest, it's been a waste of time, because obviously let's say for instance, I'm as a QS allocated sort of like 2 hours a week. I end up spending probably a whole day because I'm having to resubmit and do additional works essentially to try and claim that. But yeah,
I see your frustration, but yeah. I think ultimately, hopefully, if well done, your efforts will sound in the final account, in the final assessment, because the evidence will be marshaled with appropriate notices in place. Then they will have no option but to include it. And if they don't include it, the third party adjudicator will.
Yeah, thank you.
So again, Wally, maybe again, we talk about that afterwards as to see if there is any assistance that we can give you as to how to move that one forward.
Thank you.
Fantastic. Thank you, Wally. Now, do we have any more questions? I don't know if those who are looking at the chat, if there's any in the chat.
Samuel?
Yes?
Can I just jump in on that last point?
Okay. Who is speaking? Sorry, Richard. Yeah, hello, Richard.
It strikes me, I don't know if that client was a public body of any form, but it sounds a familiar story of a public body that hasn't got the budget in place, fudging it off. So
unsurprising.
If it's a public body, the contractor, John, has the security that they're not going to go bust like some developer, which always factors how you approach these things. Mm-hmm. But it might be a question that somebody has to have a conversation higher up the chain about, is it a budget issue? It may be the people on the ground that are fudging things, not wanting to tell people higher up that they've got a problem, from my experience. Something to think about with his bosses.
Exactly. I don't disagree. That is a case of managing the situation. But ultimately, you find that when those higher up the food chain are notified, the objective always is to minimize the outflow.
Absolutely.
Yeah.
And then you've got to just dig in hard and wait your time with public bodies. But just a point I thought was worth making to John.
It's a good point. It's a good point. It is necessary to protect himself by serving appropriate notices and preparing his case.
Absolutely.
But ultimately, if it's a public body, they have to pay the money.
And that's
as well. It won't go bust.
Yeah, that is the joy of public bodies.
Is the pain of having to wait longer.
Yeah, you can end up having to wait a long time to get these things sorted. Yeah,
exactly.
But, anyway, I just thought I'd throw it in.
No, that's a very good point. Thank
you very much.
Yeah, sure. Ladies and gentlemen, do we have more questions? If we have more, sorry, I wonder if anyone is speaking and I'm not hearing. But if we have more questions, it'd be good to deal with them. I'm conscious of the fact that we've gone past 8 o'clock, and I'm pleased that you find it useful and you're all still staying. So if there are any questions, I'll deal with them. But if there are none, can I ask my clerking team if there are any questions in the chat?
No questions in the chat.
That we haven't dealt with?
No.
Okay.
Hi, Samuel. Sorry, can I just jump in with one?
Yeah, sure. Andrew?
Yep, Andrew, yeah. So what it is, I've actually got a client of mine who has contacted me. He's a main contractor. And basically, So it's the sort of same old story where they had a letter of intent in place, never got to getting a full contract, and the client has terminated their letter of intent with no real justification or backup, but they're pretty much tied in. They're tied up pretty well with the letter of intent that they've, they can serve a notice just to say, the letter of intent expired on a certain date, and the client reserves the right to terminate with immediate effect. Now, what had happened previously, the letter of intent was going for about 6 months, and the prelims were being assessed on a time-related basis. And now they had a letter of intent value, of which there was a number of delays notified, just basically it was effectively through a lack of design information being released, which didn't allow the contractor to progress and expend the value in the letter of intent. Now, as part of the termination, the wind up of or the assessment of the final account, the QS has come in and basically assessed the prelims on a percentage against the value of the letter of intent. Now, for the full 6 months on the run up to that, it was all done on a time related basis. So the main question really I have is the client's QS entitled to basically ignore the fact that all the prelims were assessed on a time related basis, and then on the last final account reassess it on a percentage basis, or should we be pushing back on that? I mean, obviously we are pushing back on it, but it's just I just want to get some advice on that, really.
Andrew, are you a contractor surveyor?
I work in various capacities, but in this case, yes.
Okay. It seems to me that what the PQS is coming to do on behalf of the employer is to minimize the exposure.
Yeah.
And I think the starting point is that letter of intent. What does it actually say? I tend to do a full session on letters of intent and the hazards of letters of intent. However, if I hear you correctly, your contractor has been on site for 6 months on the power of a letter of intent.
Yeah.
And how much of the project has he done in the meantime?
Probably, I mean, to be honest, not a great deal, because the packages were being let. So effectively they had only really, I suspect the letter of intent was only for probably in the tune of about 20% of the overall contract sum, or what would have been the overall contract sum. However, they were still waiting for the full design information to be released to them in order to firm up their tender.
Has he, I assume it's a new build?
No, it was a refurb.
A refurb, okay. All right. But the work is in progress, but they've now issued a notice of termination.
Yeah. Yeah.
Is your contractor off-site?
Yeah, yes, they have been, yeah.
Okay, so what you're engaged now is a fight for the money.
Yeah.
Okay. The question that you posed as to whether or not the PQS is entitled to change the basis of valuation from time basis to percentage basis is directly to be found in the letter of intent. So if you would like to email that over, I can then give you an opinion on it as to whether or not they're entitled to. It sounds to me, prima facie, that there is a reasonable precedent that's already been set.
Yeah.
Because for there to be a percentage valuation, that has to relate to the overall value. But now you're telling me that a letter of intent is limited to about 20% of the contract sum.
Yeah.
Yeah. So it's necessary to see that letter of intent so that I can give you clearer guidance as to how best to proceed. Sure. And in any event, how long has your contractor been off-site?
Probably about 3 weeks now.
Okay, they better get a move on, because obviously time is important as to their ability to recover.
Yeah.
Okay, so if you let me have sight of the letter of intent, I'll be able to give you guidance as to how you should actually respond to the PQS for the action that is taken.
Excellent.
Okay, good. Any further questions?
Just to cover a couple of topics that were brought up in the chat. There was a question about using the webinar for CPD, and we were just going to inform people and just let everyone know that we're not accredited yet for CPD.
Well, we can, to the extent that it will be valuable to attendees, we can have it accredited, and then for future webinars, then you can get CPD points. We'll do that. That's a good point. That's a good point to take in. This started as an aid memoir for clients generally to help them deal with issues, but we can then obviously add value to it and make it CPD accredited. Okay. Any further questions?
There was also a question about final accounts for FIDIC 1997
FIDIC
2017 contracts.
FIDIC. Now, obviously, I have just limited my presentation to JCT and NEC, given the popularity. But if the questioner on that one can drop me a line, we can address FIDIC. Is another form? Okay.
All right. I don't think they're in the chat, but certainly.
Okay. Any further questions? Okay. Now, absent further questions, I'm grateful to all of the attendees. And we will, of course, keep you posted on our future webinars, and we'll take the point home and deal with it with respect to it being accredited for your CPD purposes. So I'm grateful for your attendance. Thank you very much, and have yourself a great evening, and continue running your successful construction businesses. Thank you very much, and bye-bye. Bye-bye for now.
Thank you, Samuel. Thank you.
Okay, thank you.
Thank you.
Bye-bye.